Hello, everyone. Good evening. All right, my name is Crystal Ndidi Ibe. I am an attorney at the Curry Law Firm. I'd like to welcome you all to the part one of this series of Win Your Case, Small Claims Court Strategies. Today, we're discussing how to navigate small claims court, specifically disputes under $20,000. So, just to start, I'll give you a little bit of background about myself and the business. The Curry Law Firm, we are a business and real estate law firm based in Houston, Texas. We handle a variety of services for individuals and businesses, including contracts, reviews, real estate matters, also estate planning and litigation in all of those areas as well. And again, my name is Crystal Ndidi Ibe. I'm a litigation attorney with the firm. I've been a licensed attorney for almost 8 years now. And I pride myself in being able to effectively communicate with my clients to allow them to make the best decisions in all of their legal cases, and help them just feel comfortable with the process as well. So today, we are discussing a few things. First, we're going to go through what is small claims court. We'll discuss where do you start, how to move forward if you've been sued. We'll discuss trial prep and the trial itself. And also, if you guys have any questions, feel free to drop them into the chat box, and I will try my best to answer them as soon as they come up or address them at the end of the presentation. Now, first, what is small claims court? So there are many different types of courts in the Texas system. Justice courts are kind of considered at the very bottom of that court system, right? And they only cover a very small amount of claims. And it's 4 different types specifically. You've got debt claim cases. Those are when someone, usually a collection company, has a verified debt against you, and they will try to collect on that debt. You have repair and remedy cases, which falls under landlord-tenant law, where you have you are requiring a repair to be done in your apartment or the place that you are leasing from, and you're trying to get your landlord to make those repairs. There are also eviction cases, which also falls under landlord-tenant, and small claims cases, which we will be discussing today. So, what is a small claim? Right now, small claims cases cover anything under $20,000 or less. So if your amount is 1 cent over $20,000, Justice Court is not the court for you. Your claims have to be under $20,000. And this is actually an increase. It's fairly new. It's only been in effect for a few years. A few years ago, the limit was $10,000, but luckily it's been increased because there are just so many cases where if you take it to a county court or a district court, the fees might greatly outweigh what it is that you're trying to recover. So this increase to $20,000 allows a lot of different types of claims to be sorted out and finalized in justice court. So where do you start? I will say the legal system can be pretty daunting for anyone if you're not familiar with the process. However, this webinar, of course, will help you feel comfortable moving through those situations, even if you don't have a lawyer. So first, we'll discuss when you are bringing a lawsuit. If you're bringing a lawsuit, you are the plaintiff. You have a case against someone else and you want to have your rights known, or you want to get to some kind of resolution in court, okay? Now, before you bring a cause of action in a court, there are a few questions that you should ask yourself. And those questions are based on who, what, when, where, why, and how. So first, who are you suing? What are you suing for? When can you file your lawsuit? Where do you file your lawsuit? Why are you entitled to win? And how can you prove it? We'll go through each of those questions. So first, who are you suing? That's when we are talking about the parties. You've got the plaintiff and the defendant. You need to know if it's a business or if it's a person. Those questions will have an effect on how you can move about the court system, how you can represent yourself, and also how you have to serve your petition on someone, which we will talk about later. It's also important to have the address of both yourself and of the defendant. That we will talk about again later, but it goes into where you can bring your claim and also how you're able to serve them. So what are you suing for? And of course, this is focusing on just claims under $20,000, right? And just so for demonstration purposes, I will kind of give examples as if it's a contract case, which is typically what would fall under a $20,000 claim. So it's, did you perform a service for someone and they haven't paid you for that service? Or did you loan money to someone and they haven't paid you back? Or if it's something that you don't have actual documentation of and you can attach a monetary value to it, and it could be a service too, that's just not specifically stated how much someone owes you. If you're able to attach a monetary value to that and it's under $20,000, that's something that you could potentially bring in justice court as well. Next, when can you file a lawsuit? The main question here is, are you allowed to file it? There are certain considerations that you have to think of prior to actually submitting your case and filing it with the court. These are just some examples. I won't go into all of them in detail, but you've got statute of limitations. That is the timeline that you are allowed to bring your cause of action. So for some cases, the statute of limitations could be 2 years, it could be 4 years. It just depends on what you're bringing to the court. I will say it's better to file as early as you can, because if you start to get towards these statute of limitations issues, you don't want that to be something that you're battling in court when you're trying to get your claim heard. Next, again with contracts, if there is some kind of clause in the contract that has a mandatory arbitration or a mandatory mediation clause in it, that's something that could potentially prevent you from immediately going to court. A lot of times you have to go through this arbitration process or mediation process and try to sort out the matter in those venues before you bring it to court. If you skip that step, then someone could bring that up in the whole case. After you've paid the money for filing and service, you might have to halt the case completely and go to arbitration or mediation first before being able to come back to the court. And then for some cases, there are notice requirements where you have to actually give notice to the person that you're suing and give them an opportunity to fix the situation prior to you filing a lawsuit. And again, we have the cost considerations. And I specifically include this just because if you are bringing a claim in justice court, yes, the limit is $20,000, but a lot of times that's not what your claim totals to. There could be an instance where you could think, oh, I want to sue someone, they owe me $300. When you consider the cost of actually filing the lawsuit and service, that cost itself could actually equal around the same amount of what it is that you're trying to claim. So of course, it's a personal decision on if you want to move forward in the court system, or if you decide you just want to wipe your hands clean and move forward and just kind of let it go. And then you have the consideration of where do you file the lawsuit? The question is, what county and precinct are appropriate for you? So in the Texas system, you'll see a lot of courts that will say JP Court, like Precinct 3, Court 2, or, a lot of different numbers involved. Those numbers will depend on where, it depends on quite a few things. So you can bring your case either where the defendant is living, where the incidents giving rise to your claim occurred, or if you were performing a contract, where that contract was performed, or if it's some kind of property dispute, where that property is located. Under certain exceptions, this last part where you reside, where the plaintiff resides, that can be where you can bring your case, but it is only under certain circumstances. And Again, if you're navigating the court system alone, a lot of these justice courts are very pro se friendly. So if you don't have a lawyer, they do have avenues where you could just Google justice court in your area, and they'll actually have a link on there that says, "Where is my justice court?" And they'll have a full map designated where you can figure out where it is exactly you need to bring your case. So if you're able to pinpoint where where the defendant resides on the map, it'll have a big circle outline for you, and you'll be able to know that, oh, this is where I need to file my case. So then after you have all that figured out, you have to figure out, what are you entitled to win? This is where your argument comes into play. So you have to think, is there a specific legal remedy available to me? And in the context of just the examples, we're going to talk about breach of contract. That is a specific legal remedy that you can allege in your petition, and it'll go towards your argument, and you'll be able to say what it is that you are seeking in the court. But you also have to ask, what facts support your claim, which goes into how can you prove it? That is where your evidence comes in. I cannot stress this enough. You need evidence, whether that is tangible evidence, such as documents like contracts, or pictures, or text messages, or if it's spoken evidence through a witness. These things are absolutely necessary in order for you to build your case and to have a clear argument to present to the judge when it's time for you to actually go to trial. I will say again, if you are pro se, everything that you say in court, you're considered a witness for yourself. So everything you say, you're sworn in, and you're sworn in saying that you're going to tell the truth. So you yourself are a witness. You just need to make sure that you know you have your facts straight. You prep in advance, which we will get to, but make sure that you are able to have your full argument together and know what documents are relevant to your claim that will help you best present your argument to the judge. So, with all that being said, after you answer all of those questions, then we can discuss the complaint or the petition. That is the document that begins your lawsuit, and it must be filed with the court and served on the defendant or defendants. So there are typically a few things that have to be included in the complaint and petition. There's always a caption at the top. You have to have the address of yourself and the defendant. Of course, you have to sign off and say everything that you've included in that petition is true, to your best knowledge. And again, justice courts are very user-friendly. They also have forms available for you, where you can just print it out, fill out the blanks, and you can take it to court and file it. Or some courts have the option where you can actually file your documents online, and you don't have to actually be in person. With your complaint and petition, there are certain fees that are associated with starting your case. I want to say right now, including service, the fee is $149. That includes you filing your document with the court and having a constable go and serve the defendant. So after you're able to file your complaint, serve the defendant, then you wait and see what happens. So now we're going to switch gears and say, oh, you're the defendant. So what do you do? Okay, so you've been sued. Of course, that is something that nobody wants to deal with. How do you navigate from this point of view? So the defendant is the person who's been sued or accused of a bad act in a court of law. After you've been served with a lawsuit, it is absolutely necessary to file an answer. You absolutely have to defend yourself. If you do not file an answer, it's extremely likely that a default judgment will be entered against you, and you will not have a chance to defend yourself. So whatever the plaintiff is asserting against you, it's possible that because you're not there to defend yourself, they could be entitled to every single thing that they have alleged in their petition. So first, there's a certain timeline that you have to file an answer. For justice court, things tend to move fairly quickly. So you only have 14 days from the day you were served to file your answer in a justice court. Okay. And usually it's a very simple answer. Again, they do have forms online, but it typically just involves a general denial that just says, hey, I did not do this. And the plaintiff has to prove whatever they allege. There are also instances where you have affirmative defenses, where the best way to define them is saying that, yes, the plaintiff is right, but I have an excuse. So a perfect example would be you're sued because you were supposed to build something for someone and they sue you because they say you didn't build it. You could say, yes, I did not build it, but that's because they were supposed to pay me first and I never got paid. So that's an example of an affirmative defense where they didn't do something. So because they didn't do it, you could not perform your part of the agreement. There's also something called special denials, which encompasses quite a few different things. Typically, these are usually alleged when you do have a lawyer. They're very specific, and it just kind of goes to either specific points in the petition that state that either the plaintiff did not allege a proper cause of action, or they did not fulfill one of their obligations that they needed to do prior to filing the lawsuit. So it's a way to attempt to get the entire case dismissed or have the plaintiff replead everything more specifically. And then there's also the case of the counterclaim. I will say if you are asserting a counterclaim, that is something that you also still have to pay for and it comes out of your pocket. But a counterclaim is when you as a defendant are asserting claims against the plaintiff. So everything that we discuss with can you bring a lawsuit as a plaintiff, those are considerations you have to think about when you're a defendant and you're trying to bring a counterclaim. So after everyone has answered, everyone's been served, now we're going to go into trial prep. And again, justice courts are fairly quick, with some exceptions, of course, but usually they try to get to trial pretty quickly so everything can get resolved. So trial prep, your main consideration should be, what is the best way to clearly present my case in front of the judge? Practice your argument. There is no better way to plan for trial versus, no better way to practice, no better way to prepare for trial than to practice your argument, okay? You want to be able to clearly and as efficiently as possible present your case to the judge so that they can follow along and understand everything it is that you're asserting. In a sense, it is like telling a story, which is why your evidence is also important. So while you're telling the story, if you're able to say, I contracted with this person on this day, we entered to this agreement, and I have this document here, you're able to show it to the judge. You can also state, it clearly says XYZ, they didn't do this, and this is why I want my $20,000, okay? That is the easiest way to just clearly have an argument to present to the judge. And of course, that's the same thing when you're the defendant. You have to practice your argument as well. How are you going to defend yourself as clearly as possible? When it comes to preparing witness questions, even if it's just you yourself as a witness, you should think about what questions the judge might ask you, what questions the other side might ask you. Make sure that you're just able to clearly answer questions, clearly defend yourself, clearly present your argument in the best way possible, just so there aren't too many questions where people are confused or they can't follow what it is that you are arguing in court. You don't want to give too much information that is not relevant or necessary to the cause of action that you brought in. So that is why you're practicing your argument. You're just trying to narrow down the issues and present only what's necessary that will help you in your case. All right. And then after you've done all that practice, that is when you get to the trial. The trial itself, essentially, it's everything that you've been practicing. You know, there is a quote, loosely paraphrase. It just says everyone deserves their day in court. In justice court, it's easier to get to the trial position, but this is the time where you have the judge in front of you. You're able to present everything that you've practiced. You're able to fully have your day in court and be heard with your argument or with your defense. I will say the main point that you need to remember while you're at trial is to not get nervous or not get flustered. Again, that trial prep is something that should help you a little bit to calm your nerves, just so you are just a little bit more comfortable in that kind of setting. Okay. So with that being said, I do appreciate everyone for joining today. If you guys have any questions, feel free to give the Curry Law Firm a call, visit our website, or you can email me directly. We're here to answer any questions you may have or to represent you in any case that you may need our help for. If you guys have any questions, you can drop them in. Otherwise, I appreciate everyone for joining.